I told my daughter Stevie that I'd be here tonight talking in front of everybody for this NADADs or Deadbeats event, and I told her that I'd probably be a little bit nervous up here on the stage. And so she gave me, from Stones and Bones, her stone, she said that it would make me feel better, so this is going to be up here tonight with me. Ladies and gentlemen, we are here tonight to discuss methods and strategies that can be used to protect yourself against the horrors of the Canadian family court system. A system that destroys families and punishes parents for wanting to uphold their rights and responsibilities. It's a perverted system that creates its own laws, run by self-interested profiteers. It's a confusing, daunting system that penalizes disadvantaged parents for not fully comprehending procedures and their archaic rules. It's a system that's fueled by greed and power, and of course the almighty dollar. So some of you in the audience tonight has already been through the court system. I've talked to a couple of you, and you're just getting into the court system. But nevertheless, this information that's going to be provided tonight is applicable to everyone. If you have a pen and paper, I encourage you to take notes. So what we've done is we've compiled 10 lessons that can better your chances in court, give you good strategies, and also give you an overview of the whole court process itself. So we have a whole evening ahead of us, so let's get started. Charter of Rights and Freedoms. You were given the Charter of Rights and Freedoms at the door. Can everybody do me a favor and take them out for a second? In the second column, it states inequality rights. It states every individual is equal before and under the law and has the right to equal protection and equal benefit of the law. Without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So I'd like everybody to do me a favor tonight and just rip this up. Please go ahead, rip it up. The Constitution is not worth the paper that it's written on. The Canadian family court system is plagued by institutionalized gender inequality and rampant sexism. How can you have a system that is based on equality when 80% of children under the age of 12 were placed in their mother's custody in cases where a court order existed? Almost 7% were placed with the father. Whenever I talk to parents, it's usually 70% to the mother, 30% to the father. I just want to, actually, before I continue, I just want to say that this is not all dads or deadbeats, but we are a gender-neutral organization. We actually have over 58% women in the organization. For me personally, I fight for equal access to the children, and that is applicable to both men and women. So by no means is this a father-centric organization. The reality is, though, is that the broken family court system affects men more than it does women with regards to access and custody. Don't be fooled by the illusion of equality. The court system is based on a foundation of inequalities. And it is specifically these inequalities that lawmakers, judges, lawyers, and other members of the court system itself endorse and perpetuate to keep the money flowing. We have extra copies of that Constitution if you want to take one home with you tonight. So let's take a look at the family court system itself. The family court system is based on the 8 basic principles. Number 1 is to get you into the system. By creating laws that make you believe that you have to get lawyers to go to court for you and to win your case for you. Judges encouraging both parties to continue with court rather than alternate dispute resolutions. Second principle is to take your money, and they will. So they take your money from your family and transfer it to those in the system who charge fees for services, so lawyers and other professionals. So in essence, the system transfers wealth from the working class working middle-class Canadian families, to the elitist group of those in the legal profession who we refer to as lawyers. To keep the machine running. To keep the machinery of the legal system working so that those employed in the sector will continue to have work. Judges, court workers, court staff, police, they all have self-interests to perpetuate the system itself. To wear you down physically and mentally and emotionally, and generally direct you on a course that will hinder or delay your matter from getting to trial. For example, adjourning matters over and over, attempting to intimidate you into signing an order before the trial. This happens a lot in case conferences and settlement conferences. To protect self-interests. So to protect the system of lawyers and judges by hindering the gross violations and rights of rights and freedoms that children and families are being subjected to in the family court system. To keep judges and lawyers unaccountable and above the law for the harm done to children and families. Number 7, to give judges and lawyers the widest latitude possible to make their own arbitrary decisions regardless of the law. So basically, I see a lot of times they use case law to justify one of their decisions. So basically what they're doing is they're using a prior judge's bad decision in order to justify their bad decision. So in the family court system, 2 wrongs in this case do make a right. They make it illegal for anyone to represent you in court other than a lawyer, so effectively they have created their own monopoly. To perpetuate the adversarial system via gender bias. To give women, especially mothers, the upper hand in court in the most unobtrusive ways as possible. Courts are highly influenced by the feminist perspective. There's also many additional services, such as those provided by women's shelters, which provide additional services, including legal services to women at no cost, which the same services are generally not available to men. They reward conflict by granting the mother greater custody, essentially encouraging the perpetuation of conflict. So basically, if a warring couple, disagreeing couple go to court and they can't get along, they can't resolve their differences, the typical response from a judge would be to give greater access to the mother. So in fact, she's encouraged to perpetuate the conflict itself. Just one more quick note about that. I'll be talking about CAS really briefly in one of these later lessons, but what I've seen, once again, is more men being affected by the family court system itself, whereas more women come to me, come to NADADs and other organizations with CAS-related issues. So the bottom line is that these problems do affect everybody in various ways, but it affects everyone. So anyone who tears you away from your children is the enemy. There's no 2 ways about that. I just want to make a quick note about that as well. I'm always seeing parents perpetuating conflict by attacking each other in public, going on Facebook, going online, speaking in public about each other, effectively, perpetuating the conflict that they already have found themselves in, making a bad situation even worse. This is, a lot of people fall victim to this. So basically going online to badmouth your ex, it serves absolutely no purpose whatsoever. So sending nasty emails, leaving nasty telephone messages, we all understand that, your emotions are very high, of course they are, but yeah, you have to understand that that's a bad strategy to employ, and it's just going to come back to haunt you. I always say, whenever you can, wage peace with your ex, but wage war on the system. And I came up with this quote a couple years ago, and I think it's more relevant today than when I wrote it originally. My daughter's mom is always going to be my daughter's mom. I respect that. It's the system itself that allows her to do what she does. That's where I think any anger should be directed. That doesn't excuse people's responsibilities, but at the same time, you're going to go nowhere. If you spend your time attacking your ex, it's just going to come back to haunt you, and it's going to make you look vindictive and petty. And it will probably be used against you in court as well, by the way. So wage peace with your ex, but declare war on the system. So lesson number 2, know the players. I know some of you tonight use the lawyer system. For me personally, I don't endorse the lawyer system. I don't advocate for it, but I don't advocate not using it. If you feel it will be beneficial to you, then by all means. But there's things that you should know about lawyers themselves, and they are a part of the game. One of the things with not all dads are deadbeats, when people use lawyers, what I found is that they're actually no better off with a lawyer than without. And in fact, a lot of the times they're worse off with a lawyer. The reason why is because even with a lawyer, they're still going to get weekend access, maybe once a week, typical standard access. But yet, on top of this, now they have exorbitantly large lawyers' fees that they have to pay for. So financially, they're in a worse spot, and they're no better off with regards to access and custody. One of the major issues that people have when they call not all dads are deadbeats is with their lawyer. So the things like, I can't get my files from my lawyer, my lawyer's not doing what I requested, so things of this nature. Yet, one of the biggest questions I get is, can you refer me to a lawyer? So once again, it kind of goes to show about the fact that I think a lot of people are confused. They think lawyers are going to bail them out of these problems, and they're not. It doesn't excuse you from educating yourself, and that's why we're all here tonight. So basically, lawyers are also a part of the game called the family court system. Their job is to play the game of family law and make money for themselves and their fellow lawyers. They don't care if the legal process is destroying you, your children, or other members of your family, nor do they specifically care about any damage the court is doing to the community. So I would like to introduce you to 4 main types of lawyers, and when you go and speak to a lawyer, hopefully be able to recognize them.
Hi there, I'm the worst kind of lawyer. You know when people tell jokes about lawyers, call them scum, or generally have a deep-seated hatred for them? Well, they're talking about me. See, I figured out the family law game, and I know just how downright crooked it is, but I'm not going to tell you. In fact, I will use every dirty trick in the book against parents just so I can make money and make myself look good. Heck, this Maserati isn't going to pay for itself. I don't mind sucking up to the system in order to make myself look good and get what I want. I am purely motivated by power and money. Justice isn't even in my vocabulary. Heck, I feel dirty even just saying the word. I often employ the services of other crooked professionals just like myself, such as social workers, CAS workers, psychologists, and well, anyone else who wants to help me bend the rules. Sometimes I'll even tell my clients that I'm in their corner and I'll act in their best interest. There's a sucker born every second.
So ladies and gentlemen, George. Ladies and gentlemen, please meet the corrupt, lying, and totally unethical lawyer.
Hello. I have resigned myself to the fact that the system is just too powerful to change. So I've decided to turn my back on fighting for real justice and just go along with the game. You have to understand here. I do know that there's corruption and gender biases in the family court system, but I won't be able to change anything. I have a job I need to think about. I have bills. I have law school tuition I'm still paying back. I just can't rustle any feathers. On the surface, I will appear to fight for you in court though. Well, I mean, I really don't want to tick the judge off. We go golfing together, and our wives are rather close. I just feel that you have better luck in court if you just go with the flow. Is that so wrong?
Letty and Bruce? Exactly. Please meet the spineless chicken shit lawyer.
Hey there. I was here complaining about, how there's no justice in the family court system. I really don't know what they're upset about. I think the family court system is just fine. I tell my clients that they'll have a fair chance in court. Gender bias, corruption, unethical behavior, I just simply don't see it. I've been practicing law for over 15 years. You'd think I would have noticed any undesirable goings-on. I'll admit, though, I don't know too much about the Constitution, people's rights and freedoms. In my line of work, you don't really have to know all that much about these kinds of things. Thankfully, not too many people ever really ask me about my opinions on the family court system, so really, it all works out just dandy for everyone.
I'd like you to meet the just plain stupid lawyer, which you'll meet him a lot if you are searching for a lawyer. And finally,
Hello. I know how biased and corrupt the family court system is, and I will not hesitate to tell you during our first meeting of just how bad it really is. I believe in the fundamental principles of equality and justice. I will fight tooth and nail to ensure your rights are not compromised. I'm kind of like an outlaw in the legal world. I don't do any backroom deals with judges, and I'm not afraid to raise my voice if the law is being violated. The system is expensive, and I know how much of a burden it can be for parents. I'll often encourage parents to do some of their own legal work so it helps them save money and get the most mileage from the money they do have. I stand up on principle. This is, after all, why I became a lawyer in the first place. I've been told by fellow legal professionals that I am rocking the boat or that I am an outcast. Well, that just suits me fine. I'm a single parent myself, and I have empathy for other single parents. Fixing the problems has to start somewhere, right?
so please say hi to the very rare honest principal lawyer.
We don't have those here.
No, I don't think they exist. That's why I had to do that. I had to create. I do voice work as well, if anybody's. So if you're going to be finding a lawyer, this is the one that you want on your side. So there's some considerations when you're looking for a lawyer or learning more about lawyers. One thing that NADADs gets all the time is, can you refer me to a pro bono lawyer? As far as I'm concerned, there's no such thing. It's a myth. The question I always ask them is, would you go to your day job for a week for free? They're not going to help you, and they're not going to do it for free either. Never give a lawyer a large upfront retainer. Lawyers want as much money from you upfront because they know from the very beginning that their services represent very little value for the money, and it won't take you very long before you start to see how expensive their services really are and how little value you get for the money. Actually, in fact, be cautious of any business or service that requires you to pay a large upfront fee. That's just sort of the general rule. Like if you go to a gym and they ask you to pay a 3 or 4 month membership up front, large upfront fee, there's usually a reason behind that. So when lawyers do it, there's a reason behind that. Do not hire a lawyer who does not agree to follow your explicit instructions. Remember, you are employing them. They work for you. So this is true also for legal aid lawyers. They are supposed to be working for you and not the system. And I'll use finger quotations or whatever for that one. Make sure your lawyer understands that he or she is working for you, and if they don't understand that, fire him or her. This is really good, a really good bit of advice. During your initial consultation, ask the lawyer his or her thoughts on the court system. If honest, he or she will comment on the gender bias in the court system. Remember that you will often need to wade through the trash to find the one principled lawyer. And don't settle on the first lawyer that speaks to you. I see this happening all the time as well. Somebody looking for a lawyer will choose the first lawyer that gives them a free consultation, simply because maybe desperation or because finally a lawyer has talked to me. Shop around. There's this other, it was brought to my attention a little while ago, being in here in Sarnia, talking to a couple local activists, that there's some tactics that people are using with regards to lawyers. So what they will do is they will, one of the parties will go visit all the lawyers in a small city or a small town, thus rendering the other person unable to use those lawyers when they do go to court due to conflict of interest clauses. So, you know, there's a sort of a strategy employed here. But keep in mind that you technically could use the same strategy. So if there's a lawyer that you definitely don't want to go up against, go have a quick consultation with them first, knowing that you're not going to use their services. If this is the case and you can't find a lawyer locally, you might have to import a lawyer from out of town. You will be required to pay for their travel expenses as well. Do your research. So when you buy a new car, what do? You go out, you test drive it first, you do some research, you go online. Google searching the lawyer's name usually provides pretty good results. You can talk to local activists. You could go on different websites. Vern Beck from Canada Court Watch introduced a website called Canadians for... it's a website where basically it endorses accountability. You can go and search different lawyers and judges and see what people basically are saying about them. So do your research. There's nothing that you can't do to learn more about the lawyers that you're going to be using and who are going to be representing you in court. Also, ask about the lawyer's history of participating in family law trials. Inquire about the lawyer's recent history of family law cases. You could ask for contact information of his clients for referral purposes, so case numbers. Keeping in mind that all cases are public record, so you could go to your lawyer and say, what cases have you worked on in the past year, and what are their case numbers? I'd like to do some research on what you're all about. Be very cautious if a lawyer is hesitant on providing you with this information. What's the caveat emptor? Buyer beware. Have a written agreement with your lawyer outlining fees, procedures, and other conditions. It's often best with signature if possible. Never let your lawyer go to court or attend meetings without you being there as well. I see this all the time. Once again, people having a lawyer thinking that the lawyer is going to fix their problems. The lawyer can represent them in court without them being present, so without the father and mother being present. You should always go, absolutely, make sure you go to every single court appearance that you have to. Fire your lawyer if he or she does not act in your best interest. This is kind of a no-brainer, but most people put up with the BS, and their problems would be virtually eliminated if they simply fired their lawyer. They are a dime a dozen, unfortunately, so I don't think you'll have a hard time finding a new one if you fire him or her. Okay, so next you'll often hear when you get into the family court system, judges basing their decision on what's in the best interest of children. So how do judges determine what's in the best interest of a child? So we've established what the system is and who the players are. Now we'll take a look at how these decisions are made. In a custody hearing, the vast majority of judges will make their decision based on what is in the best interest of the child. Section 16(8) of the Divorce Act states, a court making a custody order shall take into consideration only the best interests of the child of the marriage, as determined by reference on the conditions, means, needs, and other circumstances of the child. In Ontario, the Children's Law Reform Act expresses these merits. So for a parent to achieve any reasonable amount of success in a custody hearing, the arguments surrounding the best interest of the child must be clearly conveyed to the courts by the end of trial. You can answer that if you want.
Turn that off, please.
You can answer it.
Hello.
Often what I'll see, I've been doing NADADs or deadbeats for 5 years, and I've read probably hundreds of different final orders, and almost all of them had the judge made references to what's in the best interest of a child. This is the criteria that they're looking for, and this is what they will be looking for when you go to trial, they'll be looking for key things in your presentation. And oftentimes what will happen is people going into court, they have no idea about the best interests. And it'll often end up in a he said, she said, hearsay kind of battle, and just really bad strategy. Make sure when you're going to court that your presentation speaks to the best interest of the child as outlined in the Children's Law Reform Act and referenced in the Divorce Act. So what are the 7 criteria for determining what is in the best interest as according to Ontario law? Number 1, the love and affection and emotional ties between the child and the parent. The views and preferences of the child. One of the questions that NADADs always gets asked is, at what age can my child speak out in court and give his or her views and preferences? From my understanding, there's no real set age, but it's generally around the age of 12, 13 that they will start considering the views and needs of the child, desires of the child. It is a shame that courts don't give more consideration to this. My daughter Stevie came up to me a couple weeks ago, out of the blue. She said, "Daddy, I wish that I could be with you one day and with Mom the next day, because that would be fair." And she's only 5. She gets it. So I think I know our children are far smarter than the courts give them credit for. Another consideration in the best interest of a child that judges look for is the length of time the child has lived in a stable home. This is something that you need to be very considerate about. When your ex leaves your house with the kids, you must be proactive in establishing custody immediately. So I've seen many parents fall victim to this. So one parent will leave the house under the guise of, "Oh, we're just taking a break. We just need a bit of a separation." So a couple days turns into a week, which turns into a month. Next thing you know, she's established de facto custody by claiming that she has a new stable home for the kids, and she will use this in court, and it will be an uphill battle for the father. A bit of advice that I personally give is that if there is any sort of conflict in the home, and your wife or husband, I guess it could apply both ways, wants to have a bit of a break and separate for a little bit, then he or she is more than entitled to go take a week's vacation. But the kids are staying in the home, and so are you. What's the saying? Possession is 9/10 of the law, or something like that. It's really true when it comes to family court. That scenario that I just told you about, ex leaving the house with the kids, that happened to me. And what happened in the time that she left, because you don't know what you're getting into at first, right? And you try to build those bridges back up. You're still trying to make it work, and the whole time it's little did I know that time that I was spending trying to make the relationship work was working in her favor when we went to court, since she established de facto custody because she had my daughter in her possession longer than the time that I had her. Another consideration, the ability and willingness of the parent to provide the child with guidance, education, and the necessities of life, and also any special needs of the child. Proposed plans for the care and upbringing of the child. We'll be discussing this in the next section. Permanence and stability of the family unit. The relationship by blood or through adoption. So just make sure when you're putting together your motion, when you're putting together your evidence, and we're going to be going over evidence after the break, that it needs to speak to those seven considerations in the best interest of the child. That's what the judge will be looking for. That is what is going to be in your final order, and that is what is going to determine your access.
Yep. You speak about the de facto custody, and what if you got no choice? You have no say in the matter.
That's effectively what de facto custody is. It's custody not by law. It's just, you know, she becomes the primary caregiver, and by that fact, she has primary de facto custody.
I guess there are ways around that.
Go to court. Yeah, you need an order to change that. Otherwise, typically, if the kids are in her possession, then she's the primary caregiver. She's also the de facto. She has de facto custody. So, oftentimes, so once again, best interest of the child. Unknowing parents straying off topic or introducing superfluous motions, bringing up irrelevant information in court. This happens all the time. The other night at there was a CFFLR Candlelight Vigil on Monday night. I was talking to a gentleman, and he was basically saying that he didn't know what to put in his motion, and he was kind of fearful that it was just sort of a 3-page rambling, and he said that it was a very motion-driven, and he was concerned that he really didn't sort of hit the key areas that he thinks he should have. So he's now going to go into court, you know, not as confident. If you question your motion, then something's wrong. You need to rewrite your motion. You need to make sure that that you're very confident and secure in what your position is and what you're, you know, essentially fighting for. So when you're writing your motions, remember, if you are a good parent, nothing less than joint custody will be acceptable. I sometimes see parents basically abnegating their rights to custody, saying that, oh, it might work out better if one parent has full custody, and you know, I don't want to cause any conflict. No, you need shared parenting, joint custody, whatever you want to call it. But if you are a good parent, you shouldn't fight for anything less. You shouldn't accept anything less than that. Okay, so NADADs or deadbeats is a solution-based organization. So what do I mean by that? I mean that we provide practical solutions. I don't want to just reiterate the problems to you. I want to give you practical, solid advice so that your chances of succeeding in court are greatly increased. And in keeping with that sentiment, what I've done is we've created interactive parenting plans. So a lot of parents go to court unprepared, and once again, I completely understand. Parents don't know what to put in motions, especially if you're new to it. They don't know how detailed their motions should be. They can't anticipate future problems and therefore put it into their motions. It's understandable as this is it's a confusing and overwhelming time for parents, but it still does not excuse them from being prepared. So lack of preparation will likely result in the complete failure of your case. You will most likely lose in court if you're not prepared. You'll have greater restrictions on your parental involvement with your children. And effectively, you cannot win your case without knowing what you want. When I was in court, the judge turns around to me at one point, excuse me, and he said, well, what do you want? And what do you mean what I want? I want to be a dad to my daughter. And what do you mean? You know, how do I do that? How do I articulate what I want in court? I want to be a father. I want the greatest relationship with my daughter. I don't want to have my time impeded or restricted. And those things won't fly in court. If you're going to go into court and you take that attitude and that's what you say, it's not going to work. You need a plan. My problem was 5 years ago I didn't have a plan because this wasn't around. So here's a little intro video that I made for the interactive parenting plan.
Not All Dads Are Deadbeats, the equal parenting nonprofit organization, is proudly launching our latest support resource, the NADADs Interactive Parenting Plan. This free-to-download PDF contains over 35 pages of fair and balanced practical considerations that cover the day-to-day responsibilities of each parent, as well as resolutions on long-term child care and additional issues. Parents who make a parenting plan can ask the courts to make an order in the terms of that plan. Once made, these orders are legally binding. They have the same effect as any other parenting order made by the courts. You can use this parenting plan to generate ideas on what you want for yourself and your children, save thousands of dollars by being prepared when you consult a lawyer, feel more confident when going into the family court system by being better prepared, determine new ways of working together with your ex by understanding individual and mutual needs, assess your current situation and create practical goal-oriented plans for the future. Our comprehensive parenting plans include such topics as
access and custody. How will parenting time be shared? Who will have legal or physical custody? What is the planned weekly schedule? Holiday schedule. Over 20 different nationally recognized holidays neatly organized in an easy-to-use chart. Exchanges. How are child pickup drop-offs handled? What happens in cases of delays? Interference clauses restricting parents from interfering with scheduled times are also included. Moving. Are there any mobility restrictions? What happens if a parent wants to move away with a child? What is the proper notification?
Using this parenting plan is easy and efficient. These plans are interactive, which means you will be able to edit the document and save your progress. When you are ready to print, you can print the full document with your edited replies. We have taken great consideration to the recipients of this plan and have removed the header and footer when the plan is printed. This means that the Not All Dads Are Deadbeats logo, website, titles, etc. will not be visible on the final printed document. You may also print off a fresh, unedited version and fill it in with a pen. We have provided you with drop-down menus that contain pre-edited entries. However, you are also able to edit your own entries in the edit box. We have published the majority of sections to their own pages. This enables you to use only the sections and plans that you require. Not All Dads Are Deadbeats interactive parenting plans. You can't win your case without knowing what you want. To download the interactive parenting plan, please visit www.notalldadsardeadbeats. Please also check us out on Facebook at www.facebook.com/NADADs, NADADS. Thank you.
So we're selling those for $49. No, I'm just kidding. They're all free. We were going to make some CDs for everybody tonight, but we actually kind of ran out of time. But you can download the interactive parenting plan from the website for free. If you go to notalldadsardeadbeats.com, the link is right at the top, and there's more information about the interactive parenting plans. We also have them for sale at the back for $5, and that's just to cover printing costs. When you head into court, you will be making motions. This is Form 15A. Motions are a motion to change. So basically, these are requests that you make from the courts to make a determination. Requests that you ask the courts to make a determination. When you pay a lawyer, he is essentially putting together these motions for you. So this is, this is effectively what you're paying a lawyer for. So when you go and see a lawyer and you're paying him $200-300 an hour, he or she is basically putting together what effectively is in this 38-page document. Either way, you'll be touching upon these topics, so you might as well be comprehensive and well prepared. So once again, anything in this document can be turned into a motion in court. You can ask the court to make a decision in regards to a certain topic in the parenting plan. It can also be used before any court involvement between couples that are either together or separated. A well-drawn-out plan is applicable to everyone. And I've even encouraged these kinds of plans to happily married couples. What would we do in the event of separation? Let's have a look at these, 38 pages over a glass of wine and talk about what would happen if we ever, God forbid, did get separated. Planning for stuff like this, it's disaster planning, isn't it? It's just planning for this kind of stuff. Recently separated couples can use this before things get out of hand, before they even go to the court system itself, calming any storms and reducing further risk. So they can use these parenting plans to come to some amicable resolves before they enter the court system, which I strongly encourage. Best way to beat the family court system is to not get involved in it in the first place. So once again, they can directly attach it to a motion or motion to change form. Pages are not numbered, so you can shuffle pages. There's, I'm going to kind of read over some more of the topics, but some may apply to you and some may not. You don't have to use the whole 38-page document. It's interactive, so all you need is Adobe Acrobat Reader, and it'll allow you to fill out the form, and you can save your progress, as I mentioned. And then when you print it out, your completed form will be printed. Also, at the beginning of the NADADs or NADADs Interactive Parenting Plan is a questionnaire, which help you generate thoughts on what you want for yourself and for your children. So it's sort of like a little brainstorming thing. What do I want? What do I feel is in the best interest of the child? I'm really trying to hype up the parenting plans because I know that for a lot of people, these are going to be a game changer. This is what most people, when they go to court, they're very confused about. Once again, they don't know what to ask for. They don't know how to ask for it. These can be a huge difference, can make a huge difference for people and save them a lot of money and grief and time and energy. So once again, they're very fair and balanced. They're not father-centric. They're equitable for everyone involved. We've been over it many times and with a fine-tooth comb. And in order to make it very universally applicable for men and women, this is in the best interest of the children. A couple other parenting plan topics. I'm going to just list them out and think about your own personal case and think of your wants and needs and where you could use these interactive parenting plans. So access schedule, what dates and times will parents have access to the kids? Vacation schedule, how will vacations be shared between the parents? Expenses, how will expenses in the areas of transportation, education, and healthcare be shared? Records, who has access to the children's records, birth certificates, school records? How are exchanges, child pickups, and drop-offs handled? I mentioned in the video moving and mobility clauses. This is absolutely huge to put into your, absolutely vital to put into your motion. If you're going to court, you need mobility clauses in your motions. The reason why is because your ex can, if it's not in there, your ex could effectively pick up and move, thus, in a way, circumventing the order itself. And I've recently experienced this. Like 2 months ago, I was living in Chatham. My ex took my daughter to Cambridge. And so I'm kind of in this sort of temporary state of limbo as I make my way over to Cambridge. But the bottom line is that she left with my daughter again. It's the second time it happened. The first time I was living in London, she moved to Chatham, and then from Chatham to Cambridge. I did talk to a lawyer about it, and I told him the situation, and he basically said that he didn't think that an emergency motion would go through in court, and it didn't turn out well, that meeting with that lawyer. I asked him straight up, I said, look, there's a picture of you and your family behind you. I said, if your wife turns around one day and she takes your kids and moves to a different province, what would you do? Would you just throw your hands up and say, well, I can't do anything about it, I can't win? Or would you do something about it and change it? And he kicked me out, so. I have that recorded as well. Actually, what's funny about that is when I told him, the first couple of minutes of the interview went really well, and then I told him about NADADs and what we do, and his tone totally changed. He just really got on the defensive. I recorded it, and I put the recorder right on the table, and I think at that point, when I told him what we do, what I do, he realized that, oh, shit, this could be used against me, or he's going to put it out there. So he was kind of on guard. Anyways, so once again, moving, that's crucial.
Was this lawyer in town here?
It was in Chatham.
Who was this?
Maslach or something like that. Yeah. I said, actually, I turned around to him after I made that comment about his family. He was like yelling at me, saying, "Don't you bring my family into this? This has nothing to do with my family." I said, "Well, no, see, that's the problem with people like you, is that you've lost the sense of empathy and this sense of understanding and humanity. There's no humanity in what you do. You know, he doesn't care." Which is funny, if you refer back to the section we did on lawyers, if he was my lawyer and I asked him to file an emergency motion, he files an emergency motion or he's fired. And so that's sort of an example of me asking for him to file an emergency motion and him saying, "Well, no, I don't want to do that." Well, pal, you're my lawyer, so do it. So I wouldn't use this guy anyways. And, it was funny, when I left the lawyer's office, I thought, you know what, I was right, I should never have come here. You know, like, anyway. Reasonable contact rights between the child and the grandparents. And I know that I've talked to a couple people about that. We actually, in Chatham, a couple years ago, we had a grandparents' rights rally, and that was in conjunction with the CAW. And we had, I think, about 300-400 people show up. It was pretty huge. And that's one thing that doesn't generally get talked about a lot, is grandparents' rights to know their grandkids and the grandkids' rights to know their extended family. Grandparents tend to kind of get pushed to the side in all of this, unfortunately. So you can include that in your parenting plan, what happens with regards to grandparents.
Would you use this even if you have a wife?
Yeah, I would recommend filling. Yeah, absolutely. Yeah, because at the end of the day, what happens is, I would say fill it out, even if you're not going to use it in court. Fill it out to just understand what you can be asking for, and it puts you on the right track. You know what I mean? Like it really kind of keeps you in order and organized. I absolutely recommend filling it out. It's easy. A lot of them are check boxes. If you fill it out online, like if you fill out the actual form in Acrobat, there's a lot of them have drop-down menus, and you can have pre-selected entries. So it's not like it's an awful lot of work. It doesn't have to be an awful lot of work. But yeah, absolutely, it's great to just look over and just, you know, kind of see what's available, what you could ask for. The other one as well is sort of a non-interference clauses. And once again, if I had this 5 years ago, I would have saved myself some pretty massive headaches. But basically, it states that if you are with your son or your daughter or your kid, that your ex cannot interfere with your time. And recently, recently I've personally experienced that, where my weekends were starting to get planned for me. And, can you take her to this event or that event? And I didn't specifically agree to that. And then that was used against me. Oh, you can't participate in these things. Anyways, it was thrown back at me. The bottom line is, don't interfere with my time. I won't interfere with your time. I don't plan events for my daughter on weekdays when I don't have her. The understanding is that my weekend time shouldn't be compromised or interfered with. And oftentimes it'll take putting that to a motion in order to avoid any problems.
So you don't think that would work against you?
No, I think it's more than reasonable to basically say that. Oh, actually, sorry, when we go into the actual parenting plan, there's other sort of clauses in there, like unless mutually agreed upon, and there's terminology like that, so it keeps it very broad. It's not sort of strict, like you won't plan for my weekends, that kind of thing. But it's basically an understanding that, look, my parenting time with my child should not be interfered with or compromised, and I should not be penalized for wanting to maintain that. So that's really important. Okay, so a couple of years ago, I think it was about a year and a half ago, I met this next gentleman, Dave Schulenberg. He contacted me, and we got in contact somehow, and he's been a great asset to NADADs or deadbeats. his never-ending enthusiasm for what we do, unrelenting support, his ability to sort of speak to the broad picture, and that's what I really like about Dave, actually. He speaks to the broad picture of the broad spectrum of the family court system itself. So we've worked together for about a year and a half. Today was the first time I ever met him. He drove up all the way from Pittsburgh, Pennsylvania to be here. He actually is sort of heading up the American leg of NADADs or deadbeats. He is my brother from another mother. Mr. Dave Schulenberg, if we give him a hand, hook him up.
Can you tell the resemblance? Good evening, everyone. All right, I won't take up too much of your time. We're going to have a break right afterwards, so I don't like standing behind the podiums, even though I do a lot of politics back in business. Back, I promise. There you go. All right, so first of all, thank you for the warm welcome, brother. I got involved in NADADs in 2010. Basically what happens when a lot of us go through divorce is you go through all kinds of feelings about, okay, what do I want? In some cases, let's say it's the female spouse that wants the divorce. Say, okay, you want to go to counseling, and you go through the different phases. So, but let's fast forward to the point where you both are of the understanding that divorce is the only option, and then there's kids involved. In my case, I've got 2. So from that point forward, you can go on Google on the internet, and you can see a wide range of what people do. Some people start groups like Fathers for Justice and protest on cranes, and all power to them. I believe in what they're trying to express. I may not do it myself, but so be it. And a lot of these groups have a lot of similar missions. But I wanted to be more effective in what was going on, especially with regards to the outcome in my case, which is, like Dave said, I'm going to delve into mine a little bit as we go through some points. And so I ended up getting 50-50 custody. I also ended up with no child support payments. So, and I'm not trying to say that to boast. I'm trying to say that, okay, so now that I got that, how do I help you, and how do I help the people out there so that they know what to do? And so, you can be strangers in the night like Dave and I, and he did his website, and I found it, and I thought it was awesome, and version 2.0 was great. And then, obviously, a lot of the stuff that's come out since the beginning of the year is just going to be a game changer. And that's exactly what I got involved for, was to be a game changer. So, that being said, the first thing people need to do, and guys especially need to do when they go through this, is you need to think about the baggage part. That's going to control a lot of your decisions, especially if you do involve a lawyer. And one quote that I like is, I'm just going to paraphrase here, you can't reach for anything new if your hands are still full of yesterdays. This is by Louise Smith, the author of Common Sense and Other Bits of Wisdom We Tend to Forget or Ignore. As you're going to see in some of the points, that comes into play with everything, and one specific case, and bear this in mind as I go through some of these points. My rule of thumb with everything that I've gone through, with a lawyer, with my spouse, whatever, is I always ask myself the question, does me getting the last word, me, whether it's physically in person, on the phone, text message, email, does me getting the last word change the presentee in China where it regards the kids? 97% of the time, no. And I'll have an example of why later. So let's start going through some of the points that you need to sorry, 1 out of 10? Yeah, strategy, okay. So the parenting plan is essential. And actually, this will give me a quick opportunity to talk about lawyers. I did use a lawyer. I ended up spending $15,000 on a lawyer. A very good lawyer. But the key is this. And I'm not going to try to qualify which group she falls into. but in my opinion, she was good. I got what I paid for. I interviewed for my lawyers. Yes, you heard me correct. I interviewed them. Sometimes lawyers will say, okay, I'll give you a consultation, a free consultation. I'm giving you a free consultation. I am a 911 dispatcher, and I spoke to a lot of my colleagues, a lot of cops and paramedics who've gone through it, got a few referrals in terms of names. Called a few, about 5 or 6, then like 4 of them, rounded it down to 2. The one I ended up with, where there was 2, actually 3 good reasons why. First of all, taking it one step back, a lot of people, there was a person on Facebook that asked us about this event tonight, if it applies to the states. A lot of the information does. A lot is just general overview, common sense. Okay? But in the United States, and in states, certain states, judges are elected, not appointed by governors or prime ministers or premiers or whatever. So, and Pennsylvania is one of those states. So you talk about a game where lawyers are paying these judges legally through campaign contributions, so that when their case is in front of the judge, remember, I coughed in some money into your campaign fund. So that's one of the keys you want to ask in Pennsylvania anyways, and some of the states where they're elected, do you contribute to judges' campaigns? If they do, I mean, it's an ethical thing, but in a way, it's being part of the game. You need to have a foot up on the other spouse. So mine does. Secondly, the key that got me to choose my lawyer was my lawyer said that, and this is a good quote, a good lawyer knows the law, a great lawyer knows the judge. And I'm not just talking about those campaign contributions. In my case, my lawyer is an editor on the board of the bar regarding their journal. So as family division coughs up all these family decisions on a regular basis, she reviews them, as part of a committee that reviews them, and chooses which ones make it into the journal for the bar lawyers. So basically what that means is she knows, or she has a premonition anyways, of which way a judge will lean regarding vacation schedules, regarding blah, 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 you know, child support, and so forth. If you know your judge, you know, okay, this one's going to be tough, you know, we're going to have to pull this or that, you know, in terms of what kind of case law. You know. A good lawyer, a great lawyer knows the judge, and that's why I chose her. So having a strategy, that was my strategy. Now, we talk about a parenting plan.
What about a lawyer that's married to a judge in town here? Can you comment on that? Would they allow that where you're from, sir?
If that judge was, first of all, a family division, which there's a very good chance of.
Yes.
In fact, in Pennsylvania, for example, judges that are elected, 95% of the time they end up in juvenile or family division first, and before they go to criminal. If they ended up being your judge, you can ask for a change of judge and or venue. So, yes.
So that would never fly there.
That would never fly in Pittsburgh, or at least that's...
I'm moving to Pittsburgh.
The point is, you need to know that, though, okay? And you need to be cognizant of knowing that this judge is with this lawyer, and you can ask that in your interview process as well. So, because you're right.
No, you're missing my point. They're married.
I understand it, but how does the common man know that unless you ask or you do research on Google? So.
Well, it's a small town. Does everybody here know it?
Yeah, right.
Okay, we all know it.
All right. So, but I would not have known if my lawyer was or not. So, the point is, you ask that either through the attorney or research, and if you find out, bear that in mind. So, that being said, with the parenting plan, the reason the parenting plan is important as well, and I support it full-heartedly, is, as I said, I paid $15,000 for my attorney. If I would have had that parenting plan at the beginning, then I would have had to go for repeat meetings with my lawyer, cha-ching, how the clock's ticking. Even just her opening an email, when I get my monthly bill at the end of the month, 45 cents for this and $1 for that, just opening an email. So the point is, if you can minimize what you give to her or your interactions with him or her, this parenting plan will help you. And as Dave said, in the end, when they present it to the judge, that can't be the order, but they'll take it, basically copy and paste it into the format of the court's documents, and that can be your order, which is essentially what I got. So the strategy is very important to have. So let's start going through some of the strategies. Number 10. Number 10 is to ensure that all the evidence you have is before the court and on written record. Very, very important. In this day and age of smartphones, and tablets, and everything else, laptops, especially smartphones and tablets though. If they send you a text message, there are applications out there for you to take a snapshot of that text message, and it will save it as a JPEG or a PNG or whatever format you want for you to have as a picture, and you can put them, copy and paste them together, make a nice long document. But the point is that text messages don't have to be deleted and disappear into the world, into a void. You can use those in court. They will be used against you, so feel free to keep them for your own records as well, and forward those to the attorney or the judge. Email and electronics. I said earlier about getting the last word in emails. Very cautious about that, first of all, because that will be used against you, and most of the time it's because the other person's trying to pry you into a written argument as opposed to a verbal one, and now that will be forwarded and there's no contestation. But one aspect that I do push with regards to electronic stuff is, if you can, and this is something you should tell your attorney as well, and give your attorney access to, and the other attorney as well, Google, okay? Google Calendar is an awesome thing, okay? I use Google Calendar with my spouse. We keep track of the custody days, and let's say there's 1 month where she wants 2 Saturdays in a row as opposed to, basically what I have is a 3-4-4-3 system. I have Sunday, Mondays, Tuesdays, she has Wednesday, Thursday, Friday, and we have every other Saturday. That's a 3-4-4-3 system. We put that into the calendar, and I usually do it by the end of the month for the following month, so we can sort of see what's coming up. That way, as you're tracking the changes will show that she didn't in fact have X, Y, Z number of days more than you, or vice versa, or if it was, you can document that she asked for it this Saturday because she had a certain event or whatever. That way the judge later on, when he accesses it, is going to see what, basically, electronic history of all these apparently, extra days that she had, which weren't true. So, same thing with Google Documents. You can keep track of expenses for, like in our case, we use it for tracking lunch expenses. We pay half and half for that. Stuff like that. So, Google is a game changer with regards to that. But the biggest thing about electronics that I would like to say about Google especially is, if you are cautious about what you write and you use it strictly for logistical stuff like the calendar and the expenses, it takes the emotion out of everything, and now you're on fair foot. It's a fair fight. And as I said, it's been a game changer. My last custody order was in September of 11, and we're still on the same custody order because she hasn't been able to manipulate and say, oh, well, I had X, Y, number of days. In fact, she's often been more late bringing the kids to me and vice versa. So, next, number 9. Your evidence before the court should show that you have attempted alternate approaches to resolving the problem, such as mediation, family group conferencing, monitoring, prior to going to court, and that the court was your last option. I said earlier about trying to save yourself money with attorneys. That's exactly what I mean as well. When you forward this stuff, make sure you do it at the last possible second, but make sure it was documented. Very quick recap of how mine went down. In 2010, we had the G20, so a lot of stuff was going on. And then finally in December, I sat down with her, like you said, at a restaurant and said, okay, look, I'm going to give you an offer. I promised you finally an offer. You didn't participate in the counseling, so fine, we're going to go ahead with the divorce. Here's my offer. Basically, I gave her the better of the 2 cards. I gave her, I took over 2/3 of the marital debt, and the only thing I wanted in exchange was, aside from being clear about which holidays we had and stuff, and continuing to contribute to the kids' ESAs, was 50-50 custody. And so it was about a 5 or 6 page document full of little details. And at first she seemed like she liked it, and she said, okay, great. So I went and saw the attorney. That's when I started.
Okay, we're going to go over a couple more lessons. Lesson number 6, your right to record. In recent years, there have been a growing number of complaints from those attending courts about the lies, deceptions, and cover-ups that are going on in the family court system. It is well recognized by many Canadians, including high-ranking Canadian authorities, and even some judges, that perjury in family court is rampant. And this crime goes unpunished in family courts. Malicious comments and lies are often made in the courtroom by judges, lawyers, or their clients, which ultimately causes a lot of harm to children and their families, and that's putting it pretty mildly. Even some judges step over the line and make comments which are clearly biased, mean-spirited, or have racial overtones or sexual biases. Some judges act in a manner or say things that are clearly unbecoming of their position as a judge, which I've personally experienced 1 or 2 times. Family courts which involve child protection matters seem to be especially worse, as they generally are closed hearings, so the public rarely gets to witness what is really going on. So whenever I do seminars, which I haven't done in about a year, but when I was back in Chatham in London, we used to have at least one seminar, sort of a NADADs meeting each month. I would always bring up your right to record. Why is this an important topic? Why is recording your own court trial important? It's not just important, it's vital. It's absolutely vital that you understand your rights. The right to record your own court trial, I think, speaks to the heart of the issue. It serves as a symbolic representation of the tyranny and the corruption that we're faced with, the lies that we encounter in family court, and the court staffs, the judges, the lawyers, complete willingness to cover up facts, and to cover up the truth, and to hide, to make sure that there's no accountability. They also want to make it obvious that they do not want you to protect yourself. They do not want you standing up for your rights. The other thing as well with the recording thing, it's a broad appeal. It's not father-centric or mother-centric. It's everybody's right to record in court, and this applies to everybody that's going to court. So this is under the Courts of Justice Act 136 2B, or not 2B, in Canada as well, under the Criminal Code of Canada, you're actually allowed to record any conversation you're a part of. So I could technically, I could have recorded any conversation I've had tonight with you. I haven't, but I could. You do not need to notify the other party that you're recording, and this is applicable universally as well. So if you are on a phone conversation and talking to somebody in public, you can record them under the Criminal Code of Canada. But in the courts, it's the Courts of Justice Act 136. I get to use my laser pointer again. So it says, 136 is a clause in regards to taking photographs, recording audio, etc., etc. Basically it says you can't do it unless, and this is where the exception comes in, it says nothing in subsection 1, so nothing up here, prohibits a lawyer or a party acting in person or a journalist from unobtrusively making an audio recording at a court hearing in the manner that has been approved by the judge for the sole purpose of supplementing or replacing handwritten notes. Basically, if you're going to court, if you're going to trial, representing, if you're going to trial, you have the right to record your own court trial for supplementation of your notes. Now, there's some people say, well, in the manner in which the judge approves, that means that the judge has to say yes or no. No, absolutely does not. Keeping in mind that, from my understanding, that when this was written, you're talking about the late 80s. And so, digital technology has come a very long way. Back in the 80s, we're talking about tape decks and things that would otherwise be rather obtrusive, thus necessitating a judge to make a decision on where it's placed in the courtroom. But now, digital recorders are this big and or smaller, and they're unobtrusive.
Smartphone.
Yeah. Court staff will tell you that it is illegal to bring recorders into the courtroom. Security staff have been known to confiscate recorders at the door. I went with the fellas at CFFLR to the Sarnia court, and there's something pretty sinister going on here. As mentioned, I'm a tourist in your city. I'm only here for a month or two more. And I've been to many courthouses across Ontario. And when I got to Sarnia, something strange is going on in Sarnia. I'm actually writing a blog about Sarnia itself. Never before have I seen police officers out front of the actual courtroom doors. I've seen security staff downstairs frisking you and whatnot, which I actually kind of enjoy. But I've never seen the police officers outside of the actual trial doors. And that's dangerous. It just the idea, oh, sorry, and they're confiscating your cell phones. Yeah, that part. But yeah, they're taking cell phones from people and they're taking recording devices immediately at the door.
It's your right to have them.
Was that?
But it's your right to have them,
Absolutely.
and then take them away.
Yeah.
So what do you do once you take them away?
Well, that's a good question. What do you do? You know, you can go through the process. You can file complaints. You talk about it at events like this. You bring it out to the public. I joined Dave and Jim from the Canadians for Family Law Reform, which is sort of a local organization here in Sarnia, which I strongly recommend everybody checking out. They're in the back there in the red. Jim and Dave are the contacts for that. NADADs will always be around, but at the same time, they're also your go-to people here in Sarnia. So get in touch with Jim and Dave. But recently we went to Bob Bailey's office, and that was brought up, that digital recorders are being taken, and Dave's very outspoken about this in regards to constitutional rights being violated. And at the top of the evening tonight, we ripped up the Constitution. As far as I'm concerned, it's not worth the paper it's written on. If it was, then they would not be taking your recorders at the door.
Is he fighting that right now, is
Dave?
it? Bob Bailey?
No. Well, I've been to enough politicians to know that I always say, like, you can't, once again, it's like people putting their faith in lawyers. I don't personally put my faith in politicians. It's great, you know, it's part of the process of advocating for change, but you have to get out to the streets. You have to affect the climate of the culture one person at a time, and that's what we're doing tonight, right? Yep.
If you want to make a fuss about recording, grab a non-ripped up copy of the charter, look at number 8, and it talks about a legal search and seizure. The problem becomes when the police officer or court security person at the door takes away your phone. That's illegal search and seizure. The reason they do it at the door is because the judge doesn't want to be in a position where he has to make a written endorsement or an order from the bench. So he instructs the court staff to do it at the door, and then he doesn't have to write it down. If he writes it down, he's in contravention of Justice Act 136 2B that Dave's got on the screen. That's why it's done at the door. When they do it at the door, they're violating your Charter of Rights, Section 8. You have the freedom of a legal search and seizure. They don't take the phone away from you when you walk into the courthouse, so it's not an illegal device. It can't be used as a weapon. So why can't we take it into the courtroom to supplement our notes?
You can and shut them.
Sorry?
You can and shut them. I did it.
Yeah, and some of the people here, in fact, our group has been centered out, pulled out of the courtroom because we're wearing our red shirts.
That's what
taken away, and everybody else is allowed to keep them.
Yeah, that's what I was saying. Something weird is going on here. Thanks to Jim and Dave. Good going there. But yeah,
for sure. And the more the merrier. Make a fuss.
I recorded my own court trial in Chatham. I mean, it's not. It doesn't always. The reality is that some judges will, some judges won't. But they will all tell you that you cannot.
Right.
That seems to be pretty universal in one way or another. By that I mean they have court signs hanging outside the courtroom.
I think that's a lot more leniency because I'm self-represented.
Right.
So therefore.
Right. Okay, your lawyer may even tell you that you cannot record in court. Be very wary of that. That's a alarm bell, warning sign. The bottom line is using a recorder will increase accountability and ultimate justice in the courtroom. The bottom, for me, it's a matter of they say, you know, lack of accountability paves the road for tyranny. I think you can defend yourself against tyranny with this kind of evidence.
You said regarding individual contact, you don't have to let us know that you recorded the conversation. What about in court? Do you have to let the judge know?
No, well, that's a good question. From my understanding, the bottom line is that you can record in court. That's what this says. This says for supplementation of your notes. from my understanding, when you go into court and you ask, actually you just, that's the next page. When you ask the judge for, can I have the, can I use a recorder in my court trial today? What effectively you've done is you've relinquished your decision-making rights, and now it is up to the judge. The bottom line is to not ask. Don't make a big deal out of it. Don't make this big hoopla. I'm recording in court, you bastards, but just basically say, don't even say anything. Just take it out, put it down, and just record. I didn't ask for permission. In fact, when I went to court, the white little-haired court lady came up to me, and she said, "Is that a digital recorder?" And I said, "Yeah." And she said, "You're going to have to put it away." And I said, "Well, I'm not going to, because the Courts of Justice Act, if you want to hold on a second, I can show you the Justice Act." And she kind of went off in a huff, tattling on me, I'm sure. And the judge came out. My ex's lawyer stood up and said, "Your Honor, Dave's, it brought to my attention that Dave's recording his trial today." The judge that we had said, "Well, your client has the same rights and freedoms that Dave has, and I'm sure he's supplementing his notes, and I'm not going to tell him to stop." So it does work out that way, that some judges understand their jobs.
Dave, can I just add something to what you just said?
Absolutely.
When you put your recorder down and you press record and the judge comes out and says, "Is that a recorder?" Say, "Yes, Your Honor," and he's going to ask you if you're recording. Say, "Yes, I'm." Don't embellish. Just say, "It's to supplement my notes." Very important you use that word. It's to supplement my notes. If he asks you to turn it off, ask him to write an order to that effect. Very important that you do those two things. Again, supplement. I'm using this to supplement my notes. And if he says not to do it, ask him to write that as part of the order. It has to be in writing. That way you can fight it. If you go on YouTube, there's a case of someone in Toronto that did exactly that. The judge made the order. The fellow took it to the Judicial Council. When he was back in front of the same judge the next time, who had told him to turn it off, the judge had been reprimanded and said to the fellow, "Mr. Smith, have you brought your recorder with you this time?" And he said, "No, Your Honor, you said last time I couldn't." He said, "Well, if we stand down for an hour, can you go home and get it?" That's a true story. To supplement your notes, and if he says no, please will you make a written order to that, Your Honor.
What you're doing effectively is you're putting the judge in between a rock and a hard place to justify his position. So absolutely.
I don't like your chances when it comes to the end of the case.
Yeah, it's a very hard thing to do, but if you're self-represented and in court, the other person has the advantage of 4 ears. You have your ears. And if you're representing yourself, you've got bigger things to think about than whether or not you should be able to record it. You need to record your own case.
Absolutely. We absolutely have to be out by probably at the very latest 8:45. This is obviously going to go over. 8:30ish. We have to get out, otherwise I have to pay like an extra $100. So just keep that in mind if you can. So once again, it's your right to record. What I did a couple years ago was I did a digital recorder investigation. I took it upon myself to contact various courthouses. This is how we get our information. We go to the court clerk, staff, counter staff, when we're getting our motions and papers and stuff. We say, "Oh, by the way, can I do this or can I do that?" So what I did was I took it upon myself to call every single one in Ontario, recording it, of course, and asking if I can record my own court trial. And only, out of all the courthouses in Ontario, only one got it right, and I'll quickly play you a couple clips here. But that says something when the court staff don't even know their own rules and procedures. And not only that, but they give out wrong information, and they give out information that they're not specifically clear about. My position is that they don't always have to. If they don't know something, just admit it. I don't know that, but I'll check. I'll check into it. Don't make these assumptions, because that can ruin people's cases and it can ruin their lives. So,
Hey, that looks.
yeah, this is from the Sarnia Courthouse.
Hi, it's Julie from the Sarnia Courthouse. In answer to your question about a digital recorder in the courtroom, the answer is definitely no. No recording equipment, video equipment, or any such are allowed in the court. So do not bring one. Okay, thank you. Bye.
Okay, thank you. Yeah, so this is what they tell you, right? So you can't bring one. The other one I called, Perry Sound was the only one in Ontario that got it right.
Hi David, I'm Karen calling from the courthouse in Perry Sound. Regarding a message you left on my voicemail, I see that if you fall into this category, there is an exception for using an audio recording device, if that's what you're asking about. So audio recording devices are also prohibited in the courtroom, as well as cameras or video recording devices, but there is an exception for audio recording devices for note-taking purposes by a solicitor, a party acting in person, or a journalist. So if you fall under those parameters, then you are allowed to use an audio recording device for note-taking purposes only. So if you have any further questions, you can call me back at 705-746-4237. Thanks. Bye.
That's the exact answer everybody should be giving.
So if you had your own lawyer, like my son's, would you still maybe do something like that?
Oh, absolutely.
Okay.
Yeah, absolutely. Yeah, in fact, what I would encourage is anytime you're talking to police officers, CAS workers, social workers, psychologists, psychotherapists, court staff, security staff, record absolutely everything. What I used to do is, during my trial, the digital recorder batteries, I think like the 2 AAAs lasted about 2 days if I had it on constant record. So when I would go out, I would just press record and kind of put it in my pocket and forget about it. And if anything interesting happened, then I'd throw it online. And why is it important to record your own court trial? Here's a message. Here's a message. Here's a message that we got from one of our NADADs members, and this was court reporter staff leaving a message on his answer machine.
Hello, Ms. Hathaway. This is Emot, the court reporter from the court office in charge of doing the transcript of your request. I'm just calling to let you know that the transcript is completed. We're just waiting to hear back from the judge. The judge has to okay everything that is prepared. So I just wanted to let you know that the transcript is ready, but not ready for pickup just yet. It's in the judge's hands, and pending any changes he might want made.
Okay. So, yeah, so that speaks to the core of it. Pending any changes the judge wants made. What are you talking about? Changes? What kind of changes? Are you going to change what I say? Are you going to change what is change? Changes for the historical records are being changed. It's very common at NADADs or Debbie's and CFFLR and all the other organizations to hear about altered transcripts, missing transcripts. The reality is as well, is from a practical standpoint, if you record your own court trial, you have that as supplementation of your notes, which is primarily the purpose, but it's also to keep everybody on track. But the reality is that when you go to buy your transcripts at the end of the day, if you need to refer back to something, it's going to cost you potentially hundreds of dollars. So if you record it, you can avoid those costs. So it's just smart all around.
If I can just add quickly, I asked for the transcripts in Sarnia Court, and they looked at me like I was from Mars, and they really did their best to discourage it.
Mm-hmm. But asking for...
oh, yeah.
Yeah, they will. And then other times I've heard that, delays in getting the transcripts over, whatever months and stuff. Bottom line is, like, protect yourself and have all that, I don't want to say power, but have that control in your court rather than leaving it up to somebody else to potentially screw you over with, and as it happens. So if you're in court, this is something you can say, Your Honor, I'd like to inform the court that I would like to exercise my right as outlined under Section 136 of the Courts of Justice Act to record these court proceedings using my own recording equipment for the purpose of supplementing my notes, which is what Dave is speaking to. Lay it out very straight and simple, and then if the judge says no, get that in writing as far as why, The thing about the Sarnia Courthouse, what Dave and Jim, I was with Dave and Jim when we were talking to the police officer outside, and he was basically saying that, there's an order to take your phones away. There was an order that was made. There's no order that's made. It's my understanding it's true, right? That one judge cannot make an order in regards to another judge's courtroom.
We were told it was a verbal order, and when we pushed it further, first there was an order, and then when we pushed it, we said we'd like to see it. They said it was a verbal order. And we said, well, what judge? we were told what judge, and then that particular judge was only there whenever he's there, that he has no right to impart another order on another judge. Every judge has that right to make that decision and should write it down accordingly.
So off the top, I talked about judges making their own laws. Effectively, is it. Just a really kind of quick note. Always remember, every time you stand up for your rights and insist on promoting transparency and accountability in the courts by arguing to do your own recordings of the hearings and advocate for laws to promote personal recordings in the courtrooms, you are helping change a small portion of events in history which will contribute to the improvements of the administration of justice for the benefit of all children and families in your community and the nation. Bottom line is, get on board. If everybody basically just accepts these practices by the judges, then it's not going to benefit yourself. It's not going to benefit each other as well. Okay, I'll kind of whip through the next couple. The next one, lesson 7, understanding evidence. This is pretty big. A lot of people sort of gloss over evidence, talking about evidence, and talking about what is evidence. Now, when I went to my court trial, a lot of you haven't been to trial yet. The judge will ask you to present evidence. I remember when I went to my court trial, completely unprepared, admittedly. I went and I sat up at the front. He said, "Okay, we'll present your evidence now." What do you mean evidence? Evidence of what? Like I said at the beginning, like what? Not only didn't I know specifically what to ask for, other than I want to be a dad and 50-50, I want, but as far as evidence is concerned, were you looking for photos? What are you looking for? What are you looking for? What is it? What is evidence? Later I would find it. Now I know better strategies, obviously, but so I was just kind of going to go over types of evidence. One type of evidence is called prejudicial evidence. It's evidence that may be true or relevant, but is likely to push the judge to make a rash or misguided decision. So if your husband or wife had an affair 5 years ago, it is often counterproductive to bring up during your trial his or her infidelity as a sign of lack of cooperation. So you got to just make sure that your motions and your evidence, everything in your case, is not only geared toward the best interest of the child. It has the parenting plan is in place, but it also contains evidence and an understanding of types of evidence. So the next type of evidence is circumstantial evidence. It's suppositions. It's basically second or third hand without incontrovertible observation. This usually isn't allowed in court. It can be very easily argued against. I see this is a pitfall that I see all the time from parents going into court. They introduce circumstantial evidence as being their primary evidence. They make motions that are based on circumstantial evidence, and they get torn apart. Hearsay is a form of circumstantial evidence. Hearsay is a statement other than directly from the source. So basically, if you go to court and part of the evidence that is brought up in court is, well, he said this or she said that, anything with he said or she said should be directly argued against, because it's not, it's involving supposition. So when you're introducing your own evidence in court, if you were to, if part of your evidence is, well, my friend said that she, was drinking around the kids, she could turn around, her lawyer or her could turn around and say, well, do you have direct evidence of that? No, I don't. Well, now it kind of looks bad on you for making these suppositions. Recently, actually, I wrote an article on the Not All Dads Are Deadbeats website called Advocacy and Social Media Literacy, and it talks about the growing problem of hearsay, not only in courts, but also amongst ourselves, especially on Facebook. You absolutely have to not only question the source of things, but you have to ask for direct evidence. Just use that as a rule of thumb. If there's no direct evidence, move on until you do find direct evidence. Case in point, really quickly, there was a CAS, there was a graphic that I found on Facebook, or somebody posted on Facebook, which compared deaths in CAS care versus the deaths of the military. It stated that the CAS had several dozen more deaths during the time period, which was 2006 to 2010. I asked for direct evidence because it wasn't sourced at the bottom. I said, where are you getting this information from? They said Wikipedia, which is not a good source, by the way. And so I did my own research into it, and I found out that the graphic was entirely wrong, that there was, in fact, more military deaths from 2006 to 2010 than CAS deaths. The bottom line is that that's something you want to avoid. If I'm putting that graphic out to the public, I need to make sure that it's 100% accurate, and otherwise I'm going to be held accountable for what's on that graphic. And you're bullshitting the public, and I don't do that, and NADADs doesn't do that. We source our materials, and we take the time to find direct evidence. And you need to do exactly the same thing in court, because you're not going to be able to bullshit the judge. You need to have your sources, you need to have the direct evidence. Which is, direct evidence. So it's evidence arising out of fact. A piece of direct evidence is solid as a brick house. It bolsters your theory of the case and allows you to confidently declare your position. So once again, to use the example, my ex is abusive to our children. Hearsay would be, my neighbor said that she was. Direct evidence is I was there when she did it, or I have video, or you know what I mean, so some other direct, incontrovertible piece of evidence.
Now, with this direct evidence, can you use what your kids say as direct evidence, or is that?
Well, that's hearsay, right? Because it's my child said this. Okay, a good example of that is you using what your children say in court would be hearsay. Your children going to court to say, I said this, that would be direct evidence.
Okay, my daughter's got bruises on her arms. You ask her what that's from. Well, it's just discipline, Daddy.
Mm-hmm.
That's not direct evidence.
No, I'm just saying, like, that was just one example. I mean, what I would do in that case is if there's any concern about abuse or whatnot, phone the authorities, phone the police, get the police involved, have them do an investigation. I'm not saying don't disregard what your kids are saying, absolutely regard what your kids are saying, but I'm just saying that if you're presenting that in court, for example, your child comes home with, or a child, not yours, but a child comes home with a bruise on his or her arm, and you perhaps suppose that there's abuse going on. Maybe the child is young and says something alluding to that, possibly. The reality is that that child fell off of playground equipment. And if you were to bring up in court that you have questions of abuse going on in the home, when the reality is that that child fell off playground equipment, the bottom line is that if you bring that up in court without direct evidence, then you're just grasping at straws, essentially, and that's going to ruin your case. It's going to compromise your position, and it's going to make your trial, it's going to make your whole court case appear weak, basically, if you're grasping at those straws. So once again, I mean, in that situation, don't doubt what your kid says, but just know that unless there's absolute direct evidence, then it could be argued against in court. That's basically the bottom line for that.
Nobody likes to record their kids, but it might be an idea when something like that is being discussed.
Sorry, yeah, that's there are other solutions and stuff, but the idea really is to that would be a form of direct evidence, doing that. Okay, lesson 8: avoiding the 7 deadly spins. So when you go to court, you will be presenting your case. Staying true to your case is not only a matter of integrity, but also a key to success of your advocacy. So there's 7 deadly spins. There's basically seven things that you have to look out for when you go to court. And I see it all the time, people kind of ruining their cases or compromising their cases because they don't know either how to present their case or they stray from their case. So we'll just go ahead and check those out. So deviating from the theory, abandoning, digressing, or deviating from the theory of your case. So when presenting your case and managing your adversary's response to it, you'll be tempted to deviate from your considered approach and respond in the heat of the moment, speaking off the cuff or inserting a piece of evidence that relates in no way to the theory of the case. So basically, always stick to the case that has been presented. If you have a motion and you have all your evidence laid out, don't kind of have it go off in a different direction. So this could be when you're presenting something to the courts, when you're making your opening statement, when you're up on the stand. Don't arbitrarily just kind of go off in a different direction because you're flustered or whatnot. Spin number 2 is over-promising. Anywhere in your trial presentation, from setting forth your theory of your case to your final arguments, you may find yourself making large declarations about what you are going to prove or how much evidence you have. Don't over-promise what you don't have, because that could discredit you in court. Adding last-minute charges that prejudice your case. When I've sat in court, I've often seen parents lose complete control of their cases by abruptly switching gears mid-trial and attempting to head in a different direction. So it's like they get angry or whatnot, and they say, well, she also, she also does this, or this also happened, and then it goes off in a different direction. Keep all your materials relevant to your case. Keep it pertinent to your case. Keep it pertinent to the parenting plan and also the best interest of the children criteria. Inserting extraneous facts and additional charges that are not in your trial plan does not achieve any desired results. Resorting to hearsay evidence. So if you didn't hear it yourself, don't rely on it as fact. So if it's he said or she said, be questioning, be challenging to that. Making subjective characterizations. Perhaps the most prevalent of the 7 deadly spins is subjective characterization. So it's often quite natural to deviate from the facts of your case instead of establishing incontrovertible facts. So the example is, if you're explaining why you sideswiped your neighbor's car coming home from work one night, you shouldn't declare the lighting was poor that evening. The poorness of the lighting is a matter of debate, not absolute fact, so it's subjective. If you declare that there's only one street light on the entire block, then you're being factual and no one can disagree with you. So just make sure that whenever you're putting your case together, whenever you're compiling your evidence, that you're not resorting to making subjective characterizations. Stick to the facts and make it incontrovertible. Making false inferences. Persuading from false inferences, statements based or made up of false facts are likely to pass as being true is both wrong, legally and morally. False inferences basically means lying. Don't lie in court. It'll certainly come back to haunt you if you do, and they call you out on it, and then you kind of compromise your case. Expressing uncontrolled emotion. I've seen this a lot in courtrooms, and if you're going to be going into court, you have to understand that you have to kind of maintain your composure. Otherwise, you can compromise your case. Now, most people going into court are generally unaware of the CAS, but most people who have been through the court process are quite familiar with the CAS. Lesson 9, I just wanted to really touch base on the Children's Aid Society. The reason why is because, that's a whole other presentation in itself. There are 53 Children's Aid Societies in Ontario. Once again, in my experience, women seem to be a little more affected by the CAS than men, and that would make statistical sense just because by virtue of the women having the children in their care more often would mean that they would also have them taken away the most, be involved with CAS the most. CAS-related issues is one of the biggest topics that NADADs gets as far as emails and questions for help and live support requests and stuff like that. So, and CPS in the States. So Ontario is the only province in Canada not allowing its ombudsman to investigate the CAS. Basically, the bottom line is CAS is a non-profit corporation. It's not government run. It's run by your tax-paying dollars, but it is a private corporation. It has absolutely no accountability or oversight whatsoever. They'll tell you that they do, but these are all internal review boards and stuff like that. And in fact, it's the ministry's CFSRB, the Family Services Review Board. It's the only complaint process for the CAS, but it will not consider any matters currently before the courts or matters that have already been decided on, which is 100% of all cases. It's every single child protection matter.